Welcome to the Deep Dive. We are incredibly glad you are here with us today.
Absolutely. It is great to be here.
If you are tuning in, you are likely that person who is endlessly curious. You are looking to grasp complex material thoroughly but efficiently.
Right. You want to cut through the noise.
Exactly. You want to avoid the information overload and just get straight to the core of an argument. And our goal today is to provide that shortcut for you.
Taking the dense reading you have in front of you and extracting the actual substance.
Today, we are looking at an excerpted article titled The Blurred Line of Juvenile Justice.
And our analytical mission today is very specific. We are going to deconstruct this text and pull out the primary thesis along with the specific evidence the author uses to build their case.
So if you are taking notes or building a summary, by the time we are done, you will have a crystal clear understanding of the core argument.
You'll have an airtight thesis statement mapped out, completely supported by the author's own claims.
But before we jump into the mechanics of this text, we do need to establish some parameters for our discussion.
Yes, this is an important caveat. The excerpt you provided touches on some highly sensitive, intensely debated, and frankly, politically charged subjects.
Right.
The text offers some very sharp critiques of the American justice system. It points out flaws in specific legislation, and it directly questions the motivations of politicians.
It does not hold back.
It really doesn't. And because of the nature of this material, I want to make our position explicitly clear to you up front. We are not taking any sides today.
None at all.
We are not endorsing the viewpoints presented in the article, nor are we arguing against them. Our role here is strictly impartial.
We are essentially just your analytical guides.
Exactly. Objectively examining how this argument is constructed and what evidence the author deploys to support it.
With those ground rules set, let's look at how the piece actually opens, because the author doesn't ease you in.
No, they start with a very heavy hook.
They immediately anchor the reader with this shocking, deeply tragic anecdote pulled from a Washington Post story. It describes an 11-year-old boy in Tennessee.
Right.
He took his father's 12-gauge shotgun from an unlocked closet and used it to shoot and kill an 8-year-old girl. And the motive provided in the text for this horrific act is just that the young girl wouldn't let the boy see her puppy.
It is a profoundly disturbing scenario, and the author uses it to force the reader to immediately confront the darkest edge of juvenile behavior.
Yeah, the piece acknowledges that the death of any child is an undeniable tragedy that demands a serious response.
But this specific heartbreaking example is utilized to highlight an immediate real-world legal dilemma. The local prosecutor in that jurisdiction was tasked with deciding whether to charge this 11-year-old boy as an adult.
Okay, let's unpack this, because this opening dilemma propels us directly into the central thesis of the entire article. So, if you're building your summary, here's the core claim you need to note.
The piece argues that, barring extraordinary circumstances, no child under the age of 17 should be sentenced to lengthy incarceration in adult jails.
And the foundation for that claim isn't just moral, it is entirely biological.
Right. The text relies on the neuroscientific consensus that the human brain does not reach full maturity until the early to mid-20s.
That biological reality is the absolute linchpin of the argument.
Because of this physiological underdevelopment, the text asserts that adolescent and prepubescent children are fundamentally incapable of fully understanding the nature and the long-term consequences of their actions.
And to bolster this biological claim, the piece looks backward. It brings in historical context to show how the legal system originally accounted for this lack of maturity.
Yes, the author introduces two foundational concepts that have been embedded in English and American common law for centuries.
First, you have the physical act itself.
Right, the actus reus, which is the guilty act.
And the second is mens rea.
Which translates to the guilty mind, or the criminal intent. The article explains that for a true crime to exist in the eyes of common law, these two elements must converge.
The physical action has to be paired with the mental capacity to actually form intent.
And this is where that historical baseline becomes crucial for understanding the article's critique. Historically, common law dictated that children under the age of 14 were legally incapable of forming mens rea.
The legal framework inherently recognized what the biological argument suggests today. You can't possess a legally culpable, guilty mind if your brain hasn't developed enough to process intent and consequence in the first place.
Therefore, children under 14 were historically shielded from adult prosecution.
Right, so if we apply that historical common law standard to the 11-year-old in that opening anecdote, the legal perspective shifts dramatically.
It does. Under that older framework, an 11-year-old who kills over a puppy while having committed a horrific actus reus biologically and legally lacks the mens rea to be processed as an adult.
But the text immediately points out that this historical protection is largely a thing of the past.
What's fascinating here is how the article maps the stark departure from that centuries-old common law tradition. Today, there is an absolute absence of a national standard regarding juvenile prosecution.
The author cites data from the Equal Justice Initiative here.
Yes, revealing that 14 states currently have no minimum age whatsoever for prosecuting children as adults.
None at all. State legislatures have systematically dismantled those common law protections. And it has led to situations where children younger than 10 years old have faced prosecution in adult courts.
And the piece doesn't just state that this shift happened, it offers a direct critique of why it happened.
And impartially reporting the author's claim here, the text argues that the dismantling of these protections wasn't driven by advancements in behavioral science or rational legal philosophy.
Instead, it claims these changes are the byproduct of emotional knee-jerk reactions from politicians passing legislation in the heat of public outrage.
To really illustrate this dynamic of reactionary lawmaking, the text examines a very specific case from Georgia in 2004. It involved an 8-year-old victim named Amy Yates.
Following her tragic strangulation, a 12-year-old neighbor named Jonathan Adams became the primary suspect. Now, under Georgia law at the time, the maximum confinement penalty for a 12-year-old was 2 years.
And the public and political reaction to that 2-year maximum was intense.
Very intense. The text notes that Adams entered a plea without admitting guilt. But the Georgia legislature, swept up in the emotion of the case, swiftly passed what became known as Amy's Law.
We increased the maximum incarceration period for juveniles to 5 years.
Right. But the critical detail the text emphasizes regarding Amy's Law is that it is now widely believed Jonathan Adams was actually innocent of the crime.
Yet the law passed in his wake remains on the books.
Exactly. This case study is used to firmly anchor the claim that when politicians draft laws based on the intense emotion of highly publicized tragedies, the resulting legislation often lacks scientific grounding and creates permanent systemic flaws.
And here is where the author uses a fantastic rhetorical device for your summary. The article highlights the profound societal contradictions that this emotional lawmaking creates.
The text points out a long list of everyday limitations placed on minors. They were legally barred from enlisting in the military, purchasing alcohol, entering into legally binding contracts.
Or making independent legal decisions.
Right. Society universally accepts these limitations. As the text notes, you only have to ask any parent to confirm that a child's brain does not function with the foresight of an adult's.
We deny minors the ability to sign a contract because we recognize they lack the cognitive maturity to fully grasp the long-term implications of that document.
Yet the justice system operates on a completely conflicting standard. The text exposes the glaring paradox where a child is deemed too immature to order a beer or sign a piece of paper, but simultaneously deemed mature enough to be held to adult standards of culpability in a criminal court.
The piece points out the absolute most extreme manifestation of this paradox. Children have been executed for crimes committed at ages where society doesn't even trust them to vote.
Having established the biological, historical, and legislative context, the text then shifts to analyze the physical reality of what happens when these contradicting laws are put into practice.
So the argument moves from philosophical inconsistency to concrete statistical harm.
And the numbers presented are deeply concerning.
Citing the Open Society Foundations, the article states that approximately 200,000 American children are charged and incarcerated as adults every single year.
Furthermore, at any given moment, there are roughly 10,000 children currently held in adult jails and prisons across the United States.
These are key statistics to include in your summary, and the text uses these statistics to set up an argument about the severe vulnerability of these minors.
Placing children in adult facilities exposes them to drastically escalated risks. The data cited indicates that juveniles in adult prisons are 5 times more likely to be raped or sexually assaulted compared to their peers in juvenile facilities.
Additionally, the risk of suicide spikes significantly when a child is placed in an adult jail.
And these statistics of assault and suicide are then leveraged to raise a major constitutional question.
The piece asks whether the prolonged incarceration of biologically underdeveloped children in adult facilities, knowing the extreme statistical likelihood of sexual violence and self-harm, violates the Eighth Amendment's prohibition against cruel and unusual punishment.
It is a profound legal escalation within the text. The argument transitions from a debate over state-level policy to a question of fundamental constitutional rights.
It challenges you to consider if treating a child as an adult in the penal system is inherently cruel due to their physiological vulnerability.
So what does this all mean for public safety? A common counterargument to this perspective is that regardless of the harshness, trying kids as adults might serve as a necessary deterrent to violent crime.
And the article anticipates this exact counterpoint.
The piece addresses the concept of deterrence directly, claiming there is virtually no empirical evidence to suggest that prosecuting juveniles as adults decreases crime rates.
In fact, the text argues that the data points in the exact opposite direction. Studies indicate that incarcerating minors in adult facilities actually increases the rate of recidivism.
Rather than deterring future crime, the text argues that the adult penal system essentially transforms salvageable youth into hardened criminals.
To reinforce this point about recidivism, the article leans on an appeal to authority.
Yes, the author brings in their own extensive professional background, citing 28 years of experience working within and around the criminal justice system.
They reflect on a time when they were trained to view juvenile courts as institutions of rehabilitation, built on the belief that children could be saved and redirected.
But the text notes a systemic shift observed over those nearly 3 decades. The claim is that the justice system has fundamentally abandoned the goal of rehabilitation in favor of what the piece explicitly terms revenge and vengeance.
By framing the motivation as vengeance rather than justice, the text strongly critiques a system that prioritizes retribution over the long-term societal benefit of rehabilitating a minor.
However, a robust analysis of this text and your summary requires acknowledging its nuances. The piece does not operate in absolute extremes.
Right. It concedes that there are, in fact, scenarios where prosecuting a minor as an adult might be appropriate.
This concession is vital for understanding the full scope of the argument. The text establishes strict criteria for these exceptions.
For adult prosecution to be justified, the offender generally needs to be older, perhaps in their late teens.
There must be a clearly demonstrated lack of capacity for rehabilitation. Furthermore, there must be undeniable evidence of significant planning of forethought,
proving that the individual truly comprehended the nature and the consequences of the act they were committing.
And that concession directly informs the ultimate solution proposed by the text. Because brain development is a gradual biological process, and because children inherently struggle with perspective and judgment, the article concludes that it is impossible to establish a bright-line rule.
A strict, arbitrary legislative age cutoff saying someone is a child at 16 years and 364 days, but an adult the next morning contradicts the reality of neuroscience.
If we connect this to the bigger picture of the text's argument, the proposed solution is a return to individualized judicial discretion.
The piece argues that the power to determine if a juvenile should face adult court should be entirely removed from the hands of politicians who pass ad hoc, reaction-based laws.
Instead, these determinations must be made on a strict case-by-case basis by judges.
And those judges shouldn't be making these decisions in a vacuum.
No, the text insists that they must utilize the expertise of psychiatrists and psychologists to evaluate the specific cognitive maturity and circumstances of the individual child standing before them.
The logic here is that the justice system already employs judges, specifically to weigh complex, nuanced circumstances.
By relying on psychological experts rather than rigid legislative mandates, the system could actually align its legal practices with the biological realities of brain development.
Let's take a moment to synthesize the architecture of the argument we have just analyzed, just to make sure you have everything for your summary.
The core thesis rests on the biological fact that brain maturity extends into the mid-20s, meaning children under 17 broadly lack the capacity for adult culpability and should not be in adult jails.
This is supported by the historical precedent of mens rea, which protected children under 14.
The argument then highlights the modern departure from that standard, pointing to the 14 states with no minimum age, and using the Amy's Law case to argue that current legislation is driven by political emotion rather than science.
This creates a societal paradox where minors cannot sign contracts but can be tried as adults.
The text then introduces the severe consequences of this paradox. 200,000 children charged as adults annually, leading to increased risks of assault, suicide, and potential Eighth Amendment violations.
Finally, the piece argues that this system increases recidivism through a focus on vengeance, concluding that a case-by-case approach utilizing judges and psychological experts is the only rational path forward.
As we conclude our analysis of this material, there is a profound philosophical implication embedded within the text logic that warrants further reflection on your part.
Yes, I love this part.
The entire argument is predicated on the neuroscientific standard that a human brain is not fully mature until the early to mid-20s, rendering adolescence incapable of fully understanding consequences.
Right.
If the legal system were to theoretically adopt this biological standard wholesale for criminal justice, would society be forced to fundamentally redefine the legal concept of adulthood entirely?
That is a fascinating thread to pull.
If a 20-year-old lacks the biological maturity to be held fully culpable for a crime, it raises questions about how society treats 18 to 24-year-olds across every other legal and civic domain.
It really challenges us to consider the ultimate consistency of how we define maturity and responsibility.
It certainly challenges the neat lines society tries to draw around human development.
We are so glad you joined us for this deep dive into the mechanics and implications of this text. We hope this breakdown leaves you with a comprehensive, nuanced understanding of the material to build your summary. Keep analyzing, keep questioning the structures around you, and we will be right here waiting for you on the next